or not there is any basis for the implied terms on which you rely.
My Lord, in my submission, not. In my submission, where it comes in, clearly one can craft the implied term in various different ways. The absolute most basic implied term is that upon exercise of the option, the freehold is to be delivered to my clients free from encumbrances.
Well, but that's a general implied term in all contracts for the sale of land.
Yes.
And if you have that, why do you need any further implied terms? And how do you meet the test of necessity for such implied term?
We don't, my Lord. And I don't press any case that we need anything more. My client would be perfectly content on this appeal, and in this case, with a conditional order that upon tender of the $10,000, the respondents are required to remove encumbrances and transfer the freehold title to my clients. That is all that we need to ask for today. I have a few submissions on why the implied term might go further, but it's not a case that I need to press with any particular enthusiasm.
Could I perhaps say what the issues on this appeal are? Number one issue, was this a suitable case for summary judgment? Number two issue, if it was a suitable case for summary judgment, was it so obviously a case for summary judgment that the master was plainly wrong to exercise her discretion in the way that she did?
Quite.
If the answer to those two questions is yes, which presumably you're going to suggest it is, the third question is, do we ourselves consider the argument and decide whether or not to give you summary judgment, or do we send it back to the locals for them to decide? Those are the issues for us. We're leaping in at the end, if you see what I mean, but I understand why you're doing it, because you're saying it's so plain and obvious that, of course, it should have been a summary judgment.
The issues are intertwined to some extent, because the test for summary judgment is whether there's a realistic prospect of defence, and in considering that test, one obviously needs to consider what the defences are. But Your Ladyship is quite right.
And what the claim is.
Indeed.
Yes.
You've put the claim quite differently from both the statement of claim and the application for summary judgment, haven't you?
Yes. That is fair.
Getting a little late.
The case was pitched higher in both the statement of claim and in the application for summary judgment. They do argue for the implied term to require removal of the encumbrance upon my client indicating a wish to exercise the option, not simply upon exercise of the option.
And are you saying there is no issue of law to be determined there?
What I'm saying is that issue of law, firstly, is a relatively straightforward one, which I would invite your lordships and ladyship to determine one way or the other, whether we're right or wrong about that. There's nothing that needs to go to trial. Yeah. If we're wrong, please tell us so. And secondly, that if we are wrong, it doesn't matter, because my fallback position is that they're required to remove encumbrances upon exercise of the option, and that will do for my client's purposes. So turning to the three issues as identified by your ladyship, the first is whether this is a case suitable for summary judgment. On that, we say the principles to be applied are those helpfully summarised by Mr. Justice Lewison, as he then was in the Easy Air case, which is at tab 3 of the authorities bundle. It's a decision that's been referred to many times since, though not, I think, at this level. The facts of the case, briefly, are that...
could you give us the electronic bundle number, please?
878.
It's page 878 of the electronic bundle, Your Ladyship.
878.
Thank you very much.
There was a company called Opal, which dealt with the mobile telephone operator O2 and had a right to connect its customers to O2's mobile network. Opal, in turn, sold the right to connect customers to O2's mobile network to a company called Easy Air. So there's this two-stage relationship. Easy Air connected a number of its customers to O2's mobile network. O2 then disconnected a large number of those customers on the grounds that O2 suspected that they were operating illegal GSM gateways. Easy Air contended that that involved a breach of contract by Opal. It said that a term should be implied, or the contract between it and Opal should be construed, such that Opal was required to prevent O2 from disconnecting Easy Air's customers. It also alleged a fiduciary duty to that effect. Opal applied for summary judgment, saying there was no such term in the contract was not to be so construed, and it was successful on that application. At one level, then, the case is helpful as an illustration of a case in which there was a fairly knotty construction question, which was dealt with on a summary judgment application. But more broadly, at paragraph 15 of his judgment, page 880 of the electronic bundle, the judge accepted the submissions of Ms. Anderson QC as to the principles to be applied on a summary judgment application. There are a number of them. I can leave you perhaps to read them without reading them out. The most important one for present purposes is number 7. So having identified that a summary judgment application mustn't turn into a mini trial, at number 7, the judge, accepting Ms. Anderson's submission, says, on the other hand, it is not uncommon for an application under Part 24 to give rise to a short point of law or construction. If the court is satisfied that it has before it all the evidence necessary for the proper determination of the question, and that the parties have had an adequate opportunity to address it in argument, it should grasp the nettle and decide it. The reason is quite simple. If the respondent's case is bad in law, he will in truth have no real prospect of succeeding on his claim or successfully defending the claim against him, as the case may be. Similarly, if the applicant's case is bad in law, the sooner that is determined, the better. If it's possible to show by evidence that although material in the form of documents or oral evidence that would put the document in another light is not currently before the court, such material is likely to exist and can be expected to be available at trial, it would be wrong to give summary judgment, because there would be a real as opposed to a fanciful prospect of success. However, it is not enough simply to argue that the case should be allowed to go to trial because something may turn up, which would have a bearing on the question of construction. And he refers to the Court of Appeal's judgment in the ICI Chemicals case, which is to similar effect, and is also in the bundle, should you wish to see it. Applying those principles to this case, what we say is that we know the arguments on construction. The arguments are as to what happens when my client pays $10,000. We say that is an exercise of the option, which requires the respondents to remove encumbrances and transfer the property. The respondents say that the true construction of the agreement is that the payment of $10,000 gives us the right to negotiate with them for an option to purchase the land on terms to be agreed.
Is that what they say?
That's
That's not what was in their defence.
It isn't, but it's the way their case is developed. It's summarised at paragraph 12 of the Statement of Facts and Issues.
Yes, I know, but having read the documents, I was rather puzzled, both by how you were putting your case and by how the defence was putting their case.
Quite, as so often, being tested in court causes the parties to refine and improve their positions, and that is where we have ended up. They say that on paying the $10,000, we will not get a right to the land, simply a right to negotiate purchase of the land on terms to be agreed and at a price to be agreed. That's a short point of construction. Whether we're right or they're right about that, it just turns on the words of the agreement and the arguments of counsel. There's no suggestion that any factual matrix evidence is going to be relevant. Certainly none is pleaded. Then on the implied term, again, that's a short question of law. And we can argue about that today or before the master if we're sent back. There's no need for any evidence on that. And so this manifestly is a case that is suitable for summary determination one way or the other. The respondents list in their skeleton the issues that they say arise in the case at paragraph 23, in their written case, sorry.
23.
Paragraph 23 on page 8, that's right. The first point they raise is as to the admissibility of the agreement. Not quite sure what that's getting at, but in any event, it doesn't matter because the terms of the
Isn't
agreement...
that a stamping point, Mr. Midwinter?
Yes.
There is a point as to whether, if the document isn't stamped, it is formally admissible as evidence in the courts in Anguilla. That is right.
Well, that's what he's talking
But
about.
it's not a point that's been raised on the pleadings, and it's not a point that matters at all because the terms of the agreement are admitted. If it were necessary to have a stamp on the document and get the document admitted into evidence, I understand it requires a payment of a few tens of dollars. It's a matter that could be rectified, but it's not something that requires the case go to trial.
Yes.
Point number 2 is on the interpretation of the agreement. This is the point that I've just addressed you on. You see in the first hyphenated point, they're saying their case that upon the payment of the $10,000, the terms of the purchase are then to be negotiated. That's their construction
But
argument.
that's existing option or future option.
Yes.
Yeah.
And so that is the construction question and the implication terms question, which I say is suitable for determination on the summary judgment application. Point 3 is whether there was a contract for sale at an agreed price. That's either part of the construction question or it's not relevant. 4 is whether there has been a breach of that implied term. Well, if the implied term is to remove encumbrances, then there has been a breach. If the implied term only requires removal of encumbrances upon exercise of the option, then there hasn't yet been a breach. They've indicated that they don't intend to comply. That's the issue that needs to be determined, whether they should comply. But we haven't yet exercised the option. So that's not something that needs to go to trial. It's a very short point. Then 5, 6, 7, and 8 are all about whether we're entitled to a specific performance. That's just a question of the remedy. And again, that's a matter for argument. And 9 is whether my client has acquired an equitable interest in the land, which we just can't see why that's relevant at all. If it is relevant, again, it's a matter of legal argument, not something that needs to go to trial.
Might that possibly be making the point that you could have registered your option in the register at Anguilla, and that if you had registered it promptly, it would have taken precedence over the 2005 charge, and so there's no need to imply a term about charges here because it was all in your hands to have protected yourself against them.
I don't know is the honest answer to that. I don't know the system for registering options and so on in Anguilla. I don't know whether that would have been an option that was open to my clients.
You've read Mr. Hare's lengthy, dogged, and very able submissions to the Court of Appeal.
Yes.
There was one point when he seems to have conceded that if he was right in saying this was an option, it could have been registered.
Yes, I have seen that in Mr. Hare's submissions. I don't know the right answer to it, and I wouldn't want to mislead your lordships by suggesting that I do. Whether we had...
You can't do any better than that. I think that the board might be entitled to assume that an option, if it is an existing option, could have been registered, Mr. Midwinter.
Well, my lord, if the board proceeds on that basis, in my submission it makes no difference to the issues on this appeal. Firstly, the question whether summary judgment should be granted. Whether my client could and should have registered the option doesn't affect the construction of the agreement.
Well, I've indicated that it might conceivably go to the implication of a term.
And indeed, if it does, then that's a matter for legal argument. It's a point that my learned friend can take. It's a point that your lordships will give such weight to as you see fit. But it's not a point that requires the case to go to trial. And it's a little difficult to see why that would depend on whether my client had an equitable interest in the land. Either the option is registrable or it's not.
Very well.
We should just look at what the master said about this, which is in her judgment at volume 4 of the record. It's at page 765 of the hard copy. One needs to add 11 to get the e-bundle number.
Oh, thank you. 776.
That's what I've got.
Having set out the facts and the defence and the evidence, the operative part starts at paragraph 23 on page 770 or 781 of the e-bundle. 770.
781.
781 of the e-bundle.
781.
Where she sets out Rule 15.2 of the Eastern Caribbean Procedure Rules, which, as you can see, are very similar to Part 24 of the English CPR. Paragraph 26, the Master referred to the judgment of Lord Wolfe in Swain and Hillman, which set out the real as opposed to fanciful prospect of success. And then at paragraphs 27 and 29, she refers to two Caribbean authorities which tend in the same direction as Mr. Justice Lewison in the Easy Air case. In the St. Lucia case, Justice of Appeal George Creck noted that the court is not tasked with adopting a sterile approach, but rather to consider the matter in the context of the pleadings and such evidence as there is before it, and on that basis to determine whether the claim or defence has a real prospect of success. And then in the Bank of Bermuda case, she noted Chief Justice Saunders saying, in response to an application for summary judgment, the defendant is not entitled without more merely to say that in the course of time something might turn up that would render the claimant's case untriable. To proceed in that vein is to invite speculation, does not demonstrate a real prospect of successfully defending the claim. The Master didn't refer to either the ICI case, I'm sure she wasn't referred to it, or the Easy Air decision, and so she doesn't quite as clearly as they would set out that if there is an issue of construction or law that arises on a summary judgment application that can determine the case, the court should grasp the nettle. And in my submission, that's where she was perhaps led into error. The Master then sets out the submissions, and the key passages start at paragraph 39. She first deals with the construction point, and on construction she says, applying the applicable rules of construction and starting by applying the ordinary meaning of the words in the agreement, I agree with the submission of the defendants that there is no ambiguity in the words expressed therein. The agreement at Clause 1 grants the claimant a right to enter into possession of Parcel 71 for 50 years on payment of $40,000, which, as stated, has been paid. Clause 2 is very clear, as it stipulates that on payment of a further sum of $10,000 at any time during the 50 years, the defendants will give the claimant the option to purchase Parcel 71. There is no ambiguity in this clause. Clause 3 is also clear that upon the exercise of the option, i.e. on payment of a further $10,000, the claimant is entitled to have the land registered in its name, and the defendants will cause this to be done. It may not be the most elegant draft, but the agreement, in my opinion, is clear. Now, unfortunately, her summary actually isn't quite clear as to which of the parties' cases she is preferring. It may be because the cases hadn't been developed very clearly before her. We would refer to the fact that she says that on payment of a further $10,000, Clause 3 is brought into effect, and that the freehold must be transferred, as meaning that she's accepting our case. A description of Clause 2 might be said to be ambiguous. But at any rate, in paragraph 40, she then goes on to identify the points which made her think the case was not suitable for summary judgment. She says the issues which such an interpretation would raise are, 1, the nature of the agreement, whether it is a contract for the sale of land or whether a lease with an option to purchase, with the contract for sale becoming effective on the exercise of the option to purchase. And then 2, it further raises the issue as to whether the claimant has exercised the option to purchase. This is not a matter which should be decided summarily. Now, point 1 is a little hard to follow. We don't see why that would make the case unsuitable for summary determination. In fact, we don't see really why it's pertinent whether the contract is regarded as a contract for the sale of land or a lease with an option which becomes a contract for sale upon the option being exercised, which is probably the orthodox Mountford and Scott analysis. When you grant an option, it's an irrevocable offer which becomes a contract of sale upon the option being exercised. That's the orthodox analysis. But in any event, it's difficult to see why that means the case needs to go to trial. And the issue of whether the claimant has exercised the option to purchase, well, we haven't exercised the option. We accept that.
Doesn't seem to have been made very clear to her that you accepted that.
No, it was made clearer perhaps to the Court of Appeal, but not to her. That is fair.
Well, if you haven't exercised the option to purchase, then while I see there's a point as to whether or not it should have been, the case should have been disposed of summarily, I cannot see how if it were disposed of summarily, it can be said that there was no defence to, no tenable defence to the stance you were taking, namely that you were implying an unnecessary term into the contract, which would simply not arise if you exercised your option and demanded a merchantable title.
Well, I have very little dispute with any of that. The point is, it would be unrealistic for my client to hand over the $10,000 at a time when the respondents are saying that the effect of that will be not that we're required to transfer the land, but that you get the right to negotiate with us for purchase terms, and moreover, we don't have any obligation to remove encumbrances.
Well, then give it to a stakeholder or put it into court. But what if you're right, and the judge should have worked on the basis that you hadn't exercised the option, for what, please, was she supposed to give summary judgment?
She was supposed to give summary judgment in the terms set out at the last paragraph of the written case, a conditional order upon tender of the $10,000.
Did anybody ask her to do that?
Well, we were asking her to go rather further.
You were asking her to go a lot further.
We were.
And you were not making it clear that you hadn't exercised the option. You were asking for an implied term that clearly, to my mind at least, can't exist, namely an obligation never to charge the land long before the option is even thought about being exercised. You are asking for specific performance of the contract of sale, which on your present case you can't possibly have because you haven't exercised the option. What's she supposed to do?
I entirely accept that the master did not have a straightforward job before her due to the way that the cases were put. We'll see in a moment that the case for the respondent wasn't put particularly clearly either.
That's probably true.
But what I submit to your lordships that one should do now, we are where we are, is get to the right result today. And the right result, in my submission, is, as I have said, an order that, upon tender of the $10,000, the respondents must remove the encumbrance and transfer the title.
So is the question whether it's now suitable for summary judgment on the very different way that you now put it, or is it whether it was suitable for summary judgment before the judge?
They are both the question in my submission.
Are you arguing that, as it was put before the judge, you were entitled to summary judgment?
I will not press the case that we were entitled to summary judgment on the way it was put to the master.
Right.
What I would say is...
So can we do more than uphold the master's decision and give guidance as to how the matter should be dealt with in future? If you accept you were not entitled to summary judgment before the master, then...
That's not quite right anymore.
What more can we do?
I submit that we were entitled to summary judgment before the master. That what the master should have done is said, you are not entitled to have the removal of the encumbrance today. What you are entitled to is an order that, upon payment of the $10,000, upon exercise of the option, they must remove the encumbrance and transfer the land to you.
Your case is that she should have done all the work, put you right, and given you what, had you pleaded it correctly, you might, you say, have been entitled to.
That is a rather pejorative way of putting it, perhaps,
I know.
But in essence, what I am submitting is that any court considering this matter, and in particular your lordships and your ladyship, should come to the right answer.
Yeah, okay.
Not considering the way the arguments have perhaps been put before. What is the right answer in this case? Does it make sense to require these parties in this extremely simple dispute to continue litigating when the right answer is so blindingly obvious?
Well, I can see that, but if we look at CPR 15.2, the court may give summary judgment on a claim or on a particular issue if it considers that the defendant has no real prospect of successfully defending the claim or issue, and you look to what was being claimed to exercise your judgment in respect of that.
Quite, but as the authorities say, this isn't a sterile process. One doesn't adopt a formalistic approach and say, well, taking the way you have pleaded it, that doesn't work, therefore I'm not granting you summary judgment. What the judge ought to do in my submission is say, well, that's not right, but this is right, this is the order I'm making.
But the fact is, you haven't exercised your option and you accept that.
Yes. Yes.
And without the exercise of the option, what entitlement did you have for specific performance?
Well, there is an argument that we were making, and which was my primary argument before your lordships, that the proper construction of this agreement was that encumbrances should be removed upon my client indicating that it wished to exercise the option, not upon exercise of the option.
Based on what principle? What implied term?
The standard implied term principle, what this agreement would be taken to mean by a reasonable person reading it, the AG Belize test. But if your lordships are not going to accept that, and I see that I'm going to face an uphill battle on that particular point, what I'm saying is that the right approach is to say I'm not entitled to summary judgment on that basis, but what I am entitled to is summary judgment on the fallback basis that at the very latest, at the time the option is exercised, the encumbrances must be removed. We were looking at the master's decision. After that addressed the construction arguments, she then went on to consider the implied term point from paragraph 42 onwards. Paragraph 48 on page 777 or 788 of the e-bundle, she noted the defendant's case. The defendants, for their part, submit that such an implied term is not warranted in order to complete the bargain made. They further submit that whether it's necessary to imply such a term is a mixed matter of law and fact which requires ventilation at a trial. They say it's a fallacy that the charge frustrated the acquisition or exercise of the option. And in oral submissions, counsel for the defendant stated that all the claimant had to do was exercise the option, pay the $10,000, and then what is there to indicate that the charge would not have been removed? And she agrees that those are issues that go to trial. Now, for present purposes, my only submission is this. Those are not issues that need to go to trial. They are issues that can be dealt with on summary judgment. And so, for those reasons, I say this case was ripe for summary judgment. It may not have been put clearly before the master, and she may be deserving of sympathy and no criticism at all for addressing the way that the case was put to her. But, in fact, this case does not raise any issues beyond short issues of construction or arguments of law that require it to go to trial, and it should be dealt with one way or the other on the summary judgment application. That then was all I intended to say about summary judgment. Turning briefly to the two defences raised by the respondents on the assumption that you are persuaded that this case is suitable for summary judgment. The first is the construction point.
Oh, don't we have another thing to think about, which is whether it is so blindingly obviously suitable for summary judgment that we're entitled to interfere with the master's exercise of her discretion?
That is true. It is an exercise of a discretion. It's a particular sort of discretion in the sense that there are guidelines and principles to be exercised. It's not simply a judge deciding with a free hand what to do. I would say that if the master did not adopt what I say is the correct approach, that is the easy air approach of grasping the nettle, where there are issues of construction and law and no issues that require trial, then that was an error of approach, which justifies interfering with the exercise of her discretion. The alternative is that this case goes on to trial, which would be a madness. There's nothing else to be argued about other than what we are arguing about before your lordships today. It would be a complete waste of everybody's time and effort.
If it had gone to trial, would it not have been tried by now?
Possibly.
I mean, I simply do not know how likely that is in the
It may be
Eastern
sensible for me
Caribbean.
to let Mr. Hare respond to that question as someone with more experience of appearing in the Anguillan court.
I think his body language.
I'm hearing
is telling
whispers
me
that
not
it certainly wouldn't have come on.
And I have a feeling that the respondent accepts that it would not have got to trial by now.
There we are. So it has turned out for the best in any event that the matter may be resolved in the most expeditious manner before your ladyship and your lordships. So I do say that there is an error of approach by the master. She should have grasped the nettle. That was an error of approach which justifies overturning her exercise of discretion. On construction, as I've said, we say the agreement is perfectly straightforward. Under clause 2, my client has an option to buy the freehold, which it can exercise by paying or tendering the $10,000, at which point the respondents must transfer the freehold. The respondent's case is that that's not right. On payment of the $10,000, all that we acquire is a right to negotiate terms of an option to acquire the freehold. And the agreement is silent as to what those terms might be or how the option might be exercised once the terms are agreed. We say that's plainly wrong. It would make this clause 2 an agreement to agree. It would be unenforceable. It's not what the words say. No reasonable person looking at those words would think that's what the parties had intended. If that is what the parties had intended, one would expect to see it set out pretty clearly.
What about the word will? You will remember that Mr. Hare was very keen to persuade the Court of Appeal really to delete that word.
Yes, my submission is that all that will means is will upon exercise on conclusion of this contract. It's not intended
will
to say
grant.
They will grant to the company an option, but the option is granted through this contract. It's not the clearest piece of drafting. I entirely accept that. It's possible that it's a hangover from the way that clause 1 is phrased. The company will enter into immediate possession. The company will grant to the company the option to purchase. They're both things that it is envisaged will happen pretty much straight away upon conclusion of the agreement. That is my own friend's best point, as it were. It says will grant. And one could, if one wished to, read these words as meaning that the respondents will at some date in the future, in return for $10,000, grant an option. One would then have to read in on terms then to be negotiated and agreed. in my submission, that's a completely unrealistic reading of this agreement. It does convert it into an agreement to agree terms for sale of the freehold, which it's very unlikely the parties would have intended. It's certainly not, in my submission, a natural reading of those words. And what is particularly striking is the inclusion of clause 3, which provides that on exercise of the option, the freehold is to be transferred.
The said option.
The said option, quite.
You say there is one already.
Yes, and they will say there is one to be negotiated. But what would be very strange would be to say, you can negotiate terms for an option, but what we are here providing is what must happen upon exercise of that option. It should all be to be agreed in the future and negotiated. If all the terms are open, why have that strict provision that upon exercise of the option, the land freehold is to be transferred? And so we say the natural construction, the only one that really makes any sense, is, as the master said, that upon payment of the $10,000, the option is exercised, and then as clause 3 says, on exercise of the option, the freehold is to be transferred. That's construction. It's a very short point. Your Lordship, your Ladyship will have a view one way or the other. The next question is whether the term is to be implied, and before your Lordships and your Ladyship, I do put my case slightly differently, or perhaps quite differently from the way it was put below, that this all really flows from the term that's implied as a matter of law, that upon exercise of an option to purchase a freehold, the vendor must transfer the freehold with clear title, free from encumbrances.
Into what contract is that term implied?
Into the agreement of the 30th of July 1984.
No, it is implied into the contract of sale that arises by virtue of the exercise of the option.
Well, that's right. But I mean, this is a knotty point of analysis. I mean, one knows that in Mountford and Scott, the orthodox analysis is that the written agreement gives rise to an irrevocable offer, which is then accepted by exercise of the option, and at that point a contract of sale arises.
Yes.
As Mr. Justice Hallman noted in the Spiro case, that has some strange features in that, of course, exercise of the option will not necessarily be effected in writing. And so if that gave rise to the contract of sale, it would fail for want of writing under the Law of Property Act 1989. And so the correct analysis may be that the original option agreement contains an irrevocable offer, which is then converted into a contract of sale by the acceptance of the offer, but upon that conversion, the contract of sale is the original written agreement. It's the only written contract there is between the parties.
Yes, and it has a term which says that on the exercise of the option and the tendering of the price, the vendor has to give an unencumbered title.
Yes.
Yes.
Yes. It doesn't say that in terms, but I would say that's implied in any contract for the sale of freehold and
Yes.
estate.
Well, I'm not taking issue with you on that, but if you have that, why do you need an implied term to take effect before you've exercised the option?
The only point to be made in favour of it is the one that I made in my written case, which is the timing point. The contract says that the land is to be transferred upon exercise of the said option. And that means that, strictly speaking, my client will pay the $10,000. The respondents are then immediately required to register the land, transfer the freehold to my clients. If there are encumbrances on the land, it may take some time to remove them. It will mean that they are, strictly speaking, in breach of their obligation under Clause 3 to transfer the freehold immediately. There is therefore some practical sense in requiring the respondents to remove the encumbrances when my client indicates that it wishes to exercise the option, so that they are removed at the time the option is exercised. That is the sense of it. Your Lordship, your Ladyship will either accept that or not. There's nothing more to be said. As I say, we are quite content with judgment on the basis that, conditional judgment, that upon tender of the $10,000, at that point the obligation to remove the encumbrances arises. I keep referring to tender of the $10,000 because, of course, they can't frustrate the contract by refusing to accept the money. So it must be on that stage that the obligation to remove encumbrances arises. I can take your Lordships to the cases on the implied term about clear title, the Leominster case, the Crosby case. I'm not sure whether I need to. It's pretty much Hornbook law.
Yes, it is. You don't.
And so with that indication, essentially I come to the end. Those are the defences raised by the respondents. The question then is, what relief is my client entitled to? On the basis that you are not going to accept my submission that the duty to remove encumbrances arose on indicating a wish to exercise the option, but instead arises when the $10,000 is tendered, then we would accept that the right order is, as indicated in the written case, a conditional one, that upon tender of the $10,000, the defendants will be obliged to remove the encumbrance and to transfer the registered freehold title to my clients. That will be a resolution of the case, and in my submission, anything else, such as sending the case back to Anguilla, would simply involve a waste of time and money that's not in anyone's interests. So unless you have any questions for me at the moment, I will sit down.
I see no questions. So thank you very much, Mr. Midwinter. Mr. Hare, do you wish to add anything?
I don't.
Yes. Forgive me, is your surname Small Davis or is it Davis?
Either is fine. I'm happy with Davis.
Well, Miss Davis.
Thank you. My lady, my lords. I start by saying that as it has been conceded, and I think rightly so, that the case is quite different from what was put to the master, and the concession of my friend that on the case as pleaded, the master could not have granted summary judgment in the terms prayed for, that the court can only, in the circumstances, uphold the master's decision. It is not right that the master's decision should be impugned when at this level, at this court, the appellants are putting a completely different case. No judgment can or could have been granted in circumstances where the option has not been exercised. And in fact, that is the force of the defense that was filed. That was the main point that was being made in the defense, that an option has not been exercised, and therefore the claimant is not entitled to any of the relief sought. If we look at the statement of claim, which is at page 19, the claim at that time, or as it continues to be as pleaded, is that this agreement was an option agreement. You see that at paragraph 3. By an agreement in writing for the granting of an option to purchase the land, the claimant agreed to pay the sum of $40,000, which was described and defined in the statement of claim as the option price. It then went on to say the defendants expressly agreed that the claimant may enter into immediate possession for a period of 50 years from the payment of the option price, and this was defined as the option period. The defendants would grant the claimant the option to purchase the land at any time within the option period upon the payment of the further sum of $10,000, the purchase price. That's the case that the master was considering. And it is clearly set out in the skeleton arguments that were submitted to the master. And your lordships, your lady, is quite right in identifying that, in fact, at the summary judgment application, the appellants declined to state clearly whether they had exercised the option or not. That was a live issue. Indeed, at the Court of Appeal, it was after many inquiries made by the court that the appellants conceded that they had not exercised the option. And of course, we say they were reluctant to make that concession because the law is clear that until the option has been exercised, there is no enforceable contract. The notice of application for summary judgment is at page 33. The draft order submitted to the master is at page 36 and 37. And what the appellant was seeking an order from the master in terms of summary judgment was that the defendants be required to remove the charge, and this is on the basis of the implied term that it would not encumber the land so as to cause problems for the acquisition and exercise of the option. That is what was stated in the skeleton argument. The second relief sought, the defendants be required specifically to perform the agreement in writing for the purposes of granting of an option to purchase the land. The master could not have made that order based on the pleadings and the submissions that were made to her.
What does paragraph 2 mean? What is the defendant's performance of the agreement for the purposes of granting an
It's
option?
not clear because at one point they say they've already acquired the option. This was an option agreement, and that it would be exercised by payment of the $10,000, which was the purchase price. But here, this suggests to me that the $10,000 is now for the acquisition of the option, which is the defendant's respondent's case.
Yes.
Well, it depends whether the last words, for the purpose of granting the option, go with perform or agreement, doesn't it? And it's not really very clear at all.
Well, I think for the purposes makes it clear that performing the agreement.
Yes, I see.
So the agreement is a granting of an option for the purchase of land. So that when one looks at the case that was pleaded, the arguments made before the master, another a slightly different argument that was made to the Court of Appeal, and a very different case that is being made to the court here, it's difficult to see on what basis the master's decision can be impugned, and indeed the Court of Appeal, because all the arguments of the Court of Appeal turned on the question of whether or not there had been an exercise of the option, and therefore there was an enforceable agreement. Not having exercised, and I hate to repeat myself, but not having exercised the option, the appellant is not entitled to any of the relief that it sought in both courts below. And here, the suggestion for the first time is that they would like to have a conditional judgment, which I'm not aware of being something open to our court in granting summary judgment, given that summary judgment procedure is for a clear and obvious case. And I would actually venture to say the very fact of the changing nature of the appellant's case makes it quite clear that this is not a case for summary judgment. It's the appellant, I must say, with respect, has had difficulty in maintaining a consistent description of the document or consistent theory of the case, even. I just want to say one word on the stamping point that had been touched upon by my Lord Wilson. The Stamp Act of Anguilla you must have, let me just find it here. You must have, it's at page, where do I have it? Page 439. Was it? Page 439 of the bundle, section 20.
It's not at 439 of the electronic bundle.
450.
450.
Oh, I'm sorry.
We have to add 11.
Section 20 of the Stamp Act. No instrument executed in any part of Anguilla or relating wheresoever executed to any property situate or to any matter or thing done or to be done in any part of Anguilla shall, except in criminal proceedings, be pleaded or given in evidence or admitted to be good, useful, or available in law and equity, unless it is duly stamped in accordance with the law in force at the time when it was first executed. So that the appellants are enjoined from even pleading it. And that was a point also taken before the master. It may not be pleaded, it may not be given in evidence, it may not be admitted to be good. My friend had said this had been, the terms have been admitted, but this is a point that has already been taken.
Does an option in Anguillan property law have to be evidenced in writing?
It is required to be evidenced in writing, yes, my lord.
Because you see, Mr. Winter says, never mind the Stamp Act, the terms are agreed.
Well, that is,
They're formally admitted in the defence, in fact.
the terms that there is an agreement. However, the fact of the matter is, we cannot by even that admission as to the existence of the agreement circumvent the provisions of the Stamp Act and the admissibility into evidence of the document.
Well, that makes the document inadmissible.
It makes a document, yes.
But the agreement, evidenced by the written defence, would still be enforceable, would it, or not?
Well, I won't go into whether it is enforceable because that's a live issue, but you mean whether or not it may be pleaded and whether a court can take evidence on it?
Yes.
Yes. Well, the fact of what occurred, but if there's not an actual agreement before the court and the parties differ as to what the agreement means, then the actual document becomes an imperative for the court to review, as so far now 3 courts have and are doing.
Well, its exact terms are admitted in the defence, aren't they?
No, they're not.
They're not. Let me have a look.
What is said in the defense, my lord, is
You want to
defence is that-
start with the statement of claim and then look at the defence.
29. What's said in the defense is that the defendants admit that they entered into the agreement dated 30th July 1984. That's all it said. It denies that there is any implied term of the agreement.
But it doesn't deny that the terms of the agreement entered into were those in paragraphs A, B and C of paragraph 3 of the statement of claim.
It goes further than that because the statement of claim exhibits the document
Absolutely.
and therefore sets out the terms, which are, I thought, but I may be wrong, specifically admitted in paragraph.
Paragraph 8 refers to clause 1. Paragraph 8 of the defense refers to clause 1. It says the claimant was to enter into immediate possession of the land. The claimant has never entered into possession of the land as it had a right to do. And mentions about the claimant's right to take steps to protect the claimant's right to possession of the land during the option period.
Is it your understanding of Section 20 that when it says that an instrument cannot be pleaded or given in evidence, your understanding is that that bars the claimants from setting out what they do in paragraph 3 of their claim? That is the terms of the agreement to be admitted?
That is correct, my lord.
Yeah, that's the stance you're taking.
That's the stance I'm taking.
Yes, I see. And I am correct, am I not, that a contract relating to land in Anguilla has to be in writing?
It must be in writing.
Yes.
Or evidenced in writing.
Or evidence in writing. Yes.
There is a difference.
We know.
So in these two circumstances, just taking these two circumstances, which are the ones that present themselves immediately, one, the fact that the option has not been exercised and therefore no enforceable contract has been created. And two, the fact that as it currently stands, the appellants cannot at this stage, or up to this stage, rely on the really improperly pleaded agreement in contravention of the Stamp Act, and primarily on the first point about the unenforceability of any agreement between the parties, we say the court need not consider the appellant's arguments at all in relation to construction of the agreement. And the appellant was not before the master entitled to judgment and is not before your lordships entitled to judgment. And I want to make another, I was going to say small point, but I'm not sure if that's the right word. There is another point that I wish to bring to your lordship's attention in light of the fact that you're being asked to yourselves consider whether or not to grant summary judgment. And that is, this appeal is actually an appeal of an interlocutory decision of the court.
Yes.
And that decisions such as those, interlocutory decisions of the court, are only appealable to Her Majesty in council by leave where the court certifies that the appeal is one that by reason of its great general or public importance ought to be submitted to the board.
Well, leave was granted and it wasn't
Yes.
opposed on your side, so we are where we are.
Exactly, I accept that, my lady, except that I say, in that light, that leave was granted, but not on a certificate of a point of great public importance, that your lordships, I say with respect, ought to be consider carefully just how far we ought to go in circumstances where this is not a final decision which has had an opportunity to be ventilated on the substantive points, and we say by way of trial, in the local courts.
You say by way of trial. I mean, it may not be necessary for our decision, but I'd be interested to know, what is it that you say needs to be led in evidence?
Well, your lordships are quite familiar with the issue of in construction of contracts, the court takes into account the factual matrix and so on.
Yes, but in the jurisdiction from which I have come, we don't let people say we must have a trial because there may be something in the factual matrix. We say to them, before you're getting a trial, tell us what there is in the factual matrix which will be relevant to the construction of the agreement. So could I ask you that question? What do you say, having considered the matter, is relevant in the factual matrix to require a trial?
I'll say this. My lord, as you've heard, the appellant owns adjoining land. The subject land is beachfront property in Anguilla, highly valuable. It's 2.5 acres of beachfront property that stands between the appellant's land and the sea. It's quite often the case in the Caribbean, and particularly a country as Anguilla, which actually sort of has a more high-end tourist and even people who invest in vacation properties, their vacation villas, etc., that they prefer to have a privacy plot, so to speak, something that buffers them and gives them a more privacy. Whether this is such a situation of it giving a buffer, a privacy plot, and or access to the beach, and that in the consideration of the parties, the question of whether a 50-year lease would have been sufficient. They would not commit forever to Anguilla. 50 years is a sufficiently long time. They can, during that period, consider whether or not they actually want to purchase. That is what the agreement actually says. You have 50 years to exercise an option to purchase the land. It doesn't say, again, another part of the factual matrix is that the defendants are Anguillians, who are very land proud and may not want to actually divest of valuable beachfront property. They like to keep it, preserve it for ongoing generations. But a 50-year lease, and they would consider at that point whether they were happy to do so, which is why it is not implausible that the terms for the sale were to be negotiated at some point in the future, when both parties have had an opportunity to assess just how much each has a desire to buy and or to sell.
Miss Davis, of course, Mr. Webster swore an affidavit in answer to the application for summary judgment more than 3 years ago.
Yes, sir.
And there's absolutely no reference to background or factual matrix there or anywhere else.
No, that is, I accept that, my lord, but I would also say, again, it's clear the strategy of the respondents at that stage was merely to rely on the fact that you can get no relief. You do not have an enforceable agreement, and that was the strategy. Your claim is wrongly brought. In fact, the defendants sought summary judgments themselves.
Yes.
So that it was like a very narrow focus and not going into everything. Furthermore, I would draw your lordship's attention to the correspondence between the appellant's lawyers and Mr. Webster. They are found at at page 54 and 55, 54 straight through to page 58. I hope the numbers are the same in the electronic bundle.
How many?
65.
Oh, so it is consistent. It's always 11 pages.
I see. Oh, thank you.
Looks like it.
Thank you. So the
That's an easier sum than many again.
Thank you. The first a piece of written correspondence dated the 22nd of May 2007, which is 5 years prior to the initiation of the suit. The appellant's lawyers say, we refer to your conversation regarding a deposit of $40,000 paid to you by Mr. Cohn during his lifetime with respect to passive land, which you're the owner. We were of the impression that the transaction involved the purchase of freehold interest. However, you indicated that the transaction involved a 50-year lease. So that disposes of the idea and provides some evidence of what the parties, and certainly the defendants, considered the agreement to be. It is not what the appellants have said, that it was actually an agreement for the purchase of land, which at one time was their position before the master, back and forth. And the second letter, which is dated 9th July, in the second paragraph, the appellants admit. As you know, the said agreement sets out the terms of a 50-year lease and an option to purchase past the 71. And then the third letter, which is 19th August 2011, in the third paragraph, we enclose the following, a copy of the option agreement. It's now being called an option agreement, granting a 50-year lease over and an option to purchase property owned by you.
So how does this help?
Well, the point that I'm trying to make here, my lord, is that this is certainly more consistent with what the parties intended the document to be. I know I was being asked about any indication as to the background and that Mr. Webster had not himself given any real background. I have answered it partly by referencing the strategy of the defendants, respondents at that time, which was really to just focus on the fact that there has been no enforceable contract brought into being. But also that the evidence that is before the court, which Mr. Webster would have been responding to, sets out what he agrees and understands the nature of the agreement to be.
Well, I mean,
It is-
ultimately, as you know, it's an objective question, and the understanding
Yes.
of either party, subjective understanding of either party, is neither here nor there.
I accept that, my lord.
And therefore, all we're looking for is the factual matrix known to both parties,
Yes, my lord.
which has a bearing on the interpretation of the contract.
Yes, my lord. And I think that all of what I've said before in relation to the nature of the property, what is commonplace for expatriates preferring to have a privacy plot, as you would have heard, the appellant never actually took possession, let's put it that way, of that lot in any way. It is an undeveloped lot. And I would say that that sort of factual matrix, the background that was known to both parties at the time, would influence and would have a direct bearing on how the court ought to interpret this agreement. Which
Certainly, what the appellant did after the agreement can't be relevant to the factual matrix at the time of the agreement.
Yes, my lord, I accept that. And that's just the point that has been made in a number of cases in relation to the court giving effect to the party's intention, that intention to be gleaned from the language they used, interpreted in the light of the relevant factual situation in which the contract was made. And your lordships are familiar with the authorities on that, particularly Rainy Sky and the ICS case. Again, and I quite like the statement that was made in the ICS case at page 912H, that reminds us that the meaning of a document is not the same thing as the meaning of words. And when we look at the words, and we've all been struggling as to what the words mean, and they can't be open to more than one interpretation. That is absolutely fair. It is completely closing one eyes. To suggest, as the appellants do, that is very straightforward. It's plain, and it's plain what the document means, when in fact they have been unable to themselves grasp the nettle of identifying for themselves what the document is and what it means, given the changing case that has been presented to the different courts.
Well, both parties are guilty of that, aren't they not?
Yes, I don't deny that. That is a fact. Which is why it goes back again to whether or not the master could be properly criticized in the exercise of her decision. This was not a plain and obvious case. Even though she had been criticized by my learned friend in saying that she did not refer to the ICS case, and whether she knew of it or not, she probably, let me just make sure I don't misquote. She said at paragraph 12 of the appellant's case that the master appears not to have been referred to Easy Air or to the ICI Chemicals case, cited as by Lewis and J as authority for his proposition number 7, and as a result, she failed to consider whether the arguments raised by the respondents involved short points of law or construction on which the court had all the necessary evidence and should therefore be decided rather than put off for trial. And that's not a fair criticism at all. I would ask your lordships just to make a note of paragraphs 40, 41, 49, 50 and 53 of the Master's judgment. At paragraph 40, she identifies the issues in her mind which such an interpretation would raise. And she says, it further raises the issue as to whether the claimant has exercised the option to purchase. At that stage, it was not admitted to the Master and therefore remained as a live issue, whether the claimant has exercised the option to purchase. Indeed, there has been some delicate, not a full-throated suggestion that an intimation of your readiness, willingness, ability to exercise the option suffices, and it does not. And that comes from the appellant's first approach of treating the agreement as an agreement for the purchase of land, in which case it is quite ordinary for a purchaser to give a notice of intention to complete. And I think that that is a sort of the thinking that might have been in the minds of the appellant in notifying the company that it was ready, willing, and able to exercise the option. But the law is clear, going back to Hare and Nickel, that an option has to be exercised in precisely the manner which is stipulated in the agreement. Indications of ability to do so or readiness to do so do not suffice. At paragraph 40, the Master says this is not a matter should be decided summarily, and that's especially having pointed to the fact that there is an issue as to whether or not the claimant has exercised the option to purchase. It would have been quite open for the appellant to have clearly indicated one way or another, but they hedged their bet. At paragraph 41, which I confess is not in the clearest of terms, nevertheless, the Master there indicated there is a need to look at the nature of the agreement on which the claimants and defendants differ, and this cannot be done summarily on a summary judgment application. I think what she means there is that there has to be consideration of the legal effect of each stage of what is being put forward of clause 1, then what does clause 1 effect, what would clause 2 effect?
If that's purely a matter of construction, a matter of law, why can that not be done on a summary judgment?
Well, if it is, and certainly, my Lord, again, we come back to the question of the factual matrix, which is relevant.
Yes, but that doesn't seem to be what she's saying. She's not hinting at factual matrix there. But
no,
if there isn't a relevant factual matrix pleaded and advanced, is there any reason why these questions could not be answered on summary judgment?
If the factual matrix has not been pleaded, if the court is having difficulty, as it appears it did, in interpreting the contract merely by reading the words, then it must have been clear that it required a trial which would then give some information as to the relevant background that was in the minds of both parties, upon which you could now objectively interpret the contract.
Do I take from that you're accepting that if there isn't a factual matrix which requires evidence, then it's a matter for summary judgment?
If there is not a factual matrix requires, yes, madam.
Thank you.
I also point your lordships to...
Well, no factual matrix was pleaded and no alternative construction was pleaded, was it?
Pardon me, Lord?
No factual matrix was pleaded and no alternative construction was pleaded on your part.
No alternative construction was pleaded, but an alternative construction was submitted upon. And again, I again remind the court of the force of the defense was directed single-mindedly on...
Yes, you haven't exercised it.
Yes.
You weren't denying that if they had exercised it, they were entitled to the property.
Well, we hadn't got there.
You hadn't got there yet, had you?
No, and what the appellants are saying here is if clause 2 is construed the way they wish it to be construed, then you would be under a duty, and there was therefore a contract of sale, you would be under a duty to grant a title free of encumbrances as a matter of land law.
Well, no, to be honest, it's not absolutely clear to me what the appellants are saying as to clause 2. What I heard my friend say is that, notwithstanding the words that are there, will grant.
Sorry, I don't think we need to determine what clause 2 means, but I'm saying if it was an option, an entitlement to exercise an option, and if they indicated they were exercising an option, and they were correct in the view that the option price was £10,000, so that you then had a completed contract of sale, is it accepted by the respondents that they would become under a contractual duty in a contract for the purchase or sale of land to provide an unencumbered title?
I would accept that if there is a contract for the sale of land, that there is an implied term to grant it. However, I differ from the appellants because in terms of an option price is not the purchase price.
Well, that's. I put it on the hypothesis that they were right. Clearly, you say that it's a price for the option, which then has to be the offer to buy then has to be a negotiation as to what the price is.
Yes, madam. And then the other point that I should make is that on the appellant's present case, there has been no consideration for the option.
Why do you say that?
Because they have conceded in the current case is as set out in paragraph.
Why can't the $40,000 be for A, the 50-year lease, and B, the option to buy at 10?
Well, the agreement does not say that, and the appellants don't say that. Well, in fact, well, I'm being assisted, my lord, in the Court of Appeal, when the appellant's counsel was being asked what's the price, and this is at page 711.
Probably. Quite sure where she is.
What are you wanting to refer us to?
To page 711 of the record, which is the transcript of the hearing in the Court of Appeal, or Justice Michel says at line 6, why can't it be, well, let me say, start at Mr. Hare, line 2.
11? Oh, that can't be right.
711? Well, I have 700 here, and so I've added the 11.
Oh, I see.
Oh, I'm sorry. I was
Well
trying
done,
to be
well
helpful.
done. You're way ahead of me. Yes, Justice Michel at
Yes.
line
Well,
7.
at line 2, Mr. Hare says, I fully respect their other views, but what he says in relation to that point is that the price hasn't been paid to exercise option. That can be nothing other than the purchase price. That's the $10,000. He's saying it can be nothing other than the purchase price. Justice Michel, why can't it be the purchase price of option as opposed to the purchase price of the land? Mr. Hare, because the exercise of the option, I'm not talking the acquisition of the option. The exercise of the option is the purchase of the land. Justice Pereira, what is the consideration for the acquisition of the option? Because one takes it that the option has value. Mr. Hare, yes. Justice Pereira, yes. What's the consideration in this agreement? Mr. Hare, the consideration is this agreement. Mr. Justice Pereira, is the agreement? Mr. Hare, the agreement itself is the consideration?
Yes.
They're saying there was no consideration. There is no valuable consideration.
Of course, Ms. Bryan, on behalf of the company, had in her affidavit described the $40,000 as, quote, the option price.
She described it as the option price. That was the case before the master. The case before your lordships now is that there is an agreement for sale. In fact, it was part of the case before the Court of Appeal as well.
But
Well, the agreement for sale would be for the 50,000, wouldn't it?
It would be
The
for the
combination of the 40,000 for the
And-
lease and the option, and the 10,000 for the freehold.
that if that was the case, and then I can't see why the parties would not have been very straightforward in saying the purchase of the land for $50,000, payable by a deposit of $40,000, a balance of $10,000. It's not clear why that simple arrangement would not have been made, rather than this one, which is now causing us all sorts of gymnastics in order to come to what exactly was the parties were about. And so we have that issue is squarely before the court as to whether or not there has been valuable consideration for the option.
well, two rights were conferred by the Websters on the company. One was a right of immediate possession, and the other was the right to exercise an option. Is that correct?
Yes, my lord, and a right.
And money passed from the company to the Websters for the conferring of those rights.
The right of possession for 50 years wasn't open-ended. 50 years, it was defined.
Yes.
So it's not as though you have a right of possession, which would be perhaps in the case of an agreement where you give immediate possession and then you conclude a contract. It specifically says in the agreement that the company will enter into immediate possession of the said land for a period of 50 years from the date hereof. That's a lease. It's not part one of an agreement for sale. I don't think that it could fairly be considered in that way.
This is what he says about the agreement for sale.
I should also point your lordships to another exchange between the court and Mr. Hare in the Court of Appeal, and that's at page 719 with the 11 already added.
Thank you. I think there's a bit of contextual stuff going on there.
So you see, my lord, I'll just be a little bit cheeky and say, if we look at the certificate of value for this appeal, because it's being suggested here,
Page 825.
it's being suggested here that the purchase price of this 2.5 acre beachfront property in Anguilla is $10,000. Which is what Justice Michel is somewhat skeptical of.
We can see what's passing. What actually matters, of course, is whether £10,000 was a sensible price whenever the agreement was it 1984?
1984, but even still, then,
It's 50 years later.
But it's a price for the 10,000 relates to the reversion, does it not? Because it's subject to a 50-year lease.
it's
On a
subject.
50-year lease, which is very different from the value of the land itself.
Well, that I accept that, but I can see in fact this according to the appellant's value, this is $625,000. There's no evidence before the court of values.
Now, it's perfectly true that Mr. Justice Michel did, about 3/4 the way through the morning, put this point to Mr. Hare. It's not a point, I think, that you have ever put anywhere. The mismatch between what you say is the consideration, $10,000, if that's right,
Yes.
and current value. I haven't seen that anywhere.
No, we haven't put it anywhere, but it exists and it's part of the factual matrix, which again, there ought to be evidence of even what was value at that time, because if, as the appellants at one time were saying, that the actual purchase price is $50,000, $40,000 being 80% deposits received up front and $10,000 to come later, that was another line that was pursued by the appellant in the wide landscape. And according to Mr. Here, is a straightforward sale agreement on that view. So we come back to, and this is just to wrap up my point in saying that there is the issue of there being no valuable consideration for this option, which the appellants say was granted. I know my friend scoffed at the interpretation, saying it was unrealistic to say the owners will grant an option at some point in the future upon payment of $10,000, but that's actually what Clause 2 says. And I should, my lords, the question of whether parties have entered into an agreement which in hindsight appears to make no sense, is not commercially sensible, is imprudent, the way it works out is harsh on one side or the other. The court cannot take that into account. It has to interpret it using the principles of construction. And for that, I have identified the cases of Attorney General of Belize versus Belize Telecom, paragraph 16. I don't think your lordships need me to take you there.
Probably not.
And as well as in the Rainy Sky.
Even less do we need to take us to Rainy Sky.
Yeah, so the point there is where there are competing interpretations, it becomes even more imperative for the court to take and to be guided by the contextual scene. And poor drafting is not a reason why the court has to rewrite the contract. In fact, I think that's what the Court of Appeal specifically said they would decline to do. That's what they were being asked to do, and they declined to do. So I close by, I probably should say something about the implied term, although I think I hope I can safely rely on the written submissions in this respect, my lords.
Does it really just come to this, that if on the exercise of an option you obtain a contract of sale which contains an obligation on the vendor to give an unencumbered title, then you don't need an implied term to deal with the situation before the exercise of the option. It wouldn't meet the necessity or business efficacy tests. Is that really the point?
Yes, my lord.
Yes.
Thank you. And then if I could just pick up just very quickly on the point that my Lord Wilson had put to my learned friend in relation to the beneficial interest. I think I've covered it somewhat in saying that it could have registered the option and therefore it would have been ahead of the 2005 charge. And really, the submissions that we make in relation to the question of whether there is a beneficial interest had to do with the argument that was being made in the court below, that by virtue of this agreement, the appellants had an equitable interest in the land right away, and therefore they had some, construe it as an equitable / beneficial interest, which ought to be protected, and that therefore the respondents could not create any encumbrance on the land. That was to address the point, that argument that was being made, that there was a breach by the creation of an encumbrance. But I think that that is quite properly, dealt with by the case of Mountford and Scott, and also in Sainsbury PLC, that no equitable interest is created in the circumstances. Unless I can assist your lordships further.
I think not, Ms Davis. You've been extremely helpful. Thank you very much indeed.
Thank you.
Yes. Mr Kentish, have you anything to add?
Not at all.
Thank you. Yes, Mr Midwinter.
Well, your lordships, I won't say very much. Just to respond to what my learned friend said about the factual matrix, our submission is that those points are not pleaded points. They're not points referred to in Mr Webster's affidavit, and in fact they are not points that are going to materially affect the construction of the agreement in any event. We would, as a matter of fact, dispute the contention that this was a beachfront property, and without wishing to give evidence, my instructions are that the client's intention here was to obtain some blocking land so as to prevent construction between his house and the sea. And the essential position is that that land was acquired for an overall consideration of $50,000, and we say that was a perfectly fair price for the time, but none of that, we say, really impacts on the question of construction, which is the central question before the board. You've heard the competing constructions of Clause 2. Ours is and remains that it is very straightforward. The agreement grants an option. The option is exercised by the payment or tender of $10,000. Upon payment or tender of that sum, the respondents are to transfer the freehold title. We say that the alternative construction put forward by the respondents can just about be made to fit with the words. The will grant wording can be made to mean that, but the words are equally, if not more, consistent with our construction, and the respondent's construction simply makes no sense. It's not something that one would ever anticipate the parties would have agreed. It becomes an agreement to agree. As Mr Hare put it in the Court of Appeal, it becomes an agreement in which my client is paying $10,000 for a lottery ticket. On the implied term, I think we're nearly on common ground. That if the agreement is construed as we contend, then upon exercise of the option, the respondents must deliver the land with clear title, free of encumbrances, and so are required to remove the $158,000 charge. And though it's been fairly put that the appellant's case is not quite as pleaded or as put before the master, I should, in fairness to Mr Hare, direct your lordships to page 677 or 688 of the e-bundle of his submissions to the Court of Appeal, where he did really get to the nub of the point. When asked, what is the implied term, he said there, the implied term would be, in other words, when you see the relief that we're seeking, do we get the land free of the $158,000 charge? And that is really what it comes down to. There are various ways to give effect to that, but that is what my client wants. That is what we have been asking for. It's what Mr Hare put to the Court of Appeal was what we are after, and it is what I'm suggesting to your lordships the implied term should be. The final question then is to come back to the fact that this is a summary judgment application, and I do respectfully refer your lordships back to the principles set out by Mr Justice Lewison in the Easy Air case. I say that this is a case where the issues raised are short points of construction and implication of terms which your lordships are able to decide one way or the other. It's not a case that needs to go to trial. It's one where the court should grasp the nettle. And in failing to grasp the nettle, the master adopted the wrong approach, which means that this court can and should reach a different result. And when it comes to reaching a result, the right answer, I submit, is for your lordships to tell the parties what the right answer is. And that is, in my submission, to make an order for summary judgment conditional upon the payment by my clients of $10,000, that the encumbrance is to be removed and the land transferred. Unless you have any other questions.
Well, yes, I do have a question. It's the invariable question. what do you say about costs? And I might ask Miss Davis this as well, because there are fairly obviously rather a lot of different answers that the board may advise Her Majesty of. And so it may be a case in which submissions should be invited on costs depending upon what our answer to the current exam paper is. That is one possibility. Another possibility, of course, is the simple costs follow the event, costs here and below follow the event. Another possibility, of course, is that it might be suggested that the claimants had dug this hole for themselves by the way in which they had pleaded and presented the case, and that were they to get what they wanted out of it, they ought to pay the price for doing so.
My lady,
Just a number of ideas floating around there.
I haven't taken instructions. I anticipate that we would invite your lordships and your ladyship to deal with costs in the main judgment. We know what the issues are. It's certainly true there are many ways in which this could come out, and the order that you make may depend upon precisely what you find. My primary submission would be that costs should follow the event in the ordinary way.
Were orders for costs made against you both before the Master and before the Court of Appeal? Yes.
Yes, if you would just turn my back for a second. I think so. Yes, there's some checking going on, but we think that's right. My fallback position, if costs are not to follow the event, would be that your lordships could consider that the appropriate approach was to leave one or two of the cost orders below undisturbed. But our position on the appeal before your lordships has been clear, set out in the written case. I haven't deviated from that at all. And if we are to win on that basis, then I would submit that at least we should get our costs before your lordships. That would be my fallback submission if you reject the submission that costs should follow the event if we are successful.
Or another permutation would be for the judgment to include a provisional disposal about costs, but giving the parties the right to make further submissions to the contrary.
Yes, we'd be content with that.
That is something that we have found a useful solution in some cases. And then we found good reasons to disagree with our provisional disposal, which of course can happen. Thank you very much, Mr. Midwinter. Ms. Davis, is there anything you'd like to say about costs?
Yes, Willard. I would say that costs ought to follow the event, and that, in fact, it may not surprise the board to know that my position is that given the changing arguments and that this new case that is now being put before your lordships, which was not put before the Master, that even if the appellants were successful, the respondents ought to have their costs. I do appreciate the board's option of making a provisional order as to costs and inviting submissions later on, but I must say that I think it's probably fairly straightforward in terms of costs, at least following the event and in the circumstances of this particular case. I recently had one matter in which the cost submissions then was like satellite litigation, which I'm sure your lordships would not like to engage in further, back and forth on that.
But you're not arguing for costs following the event necessarily. So you've just said if the appeal succeeds, you want your costs.
Well, I'm actually saying I should get my costs in any event.
Yes, that is what you're saying.
Yes.
And we understand why.
Thank you.
Yes. Well, our thanks are due to everyone who's been involved in presenting this fascinating short case before us, and the spirit with which it has been presented. We're most grateful to you. We will, of course, take time, but hopefully not too much time, to consider what advice we will humbly tender to Her Majesty. The court is now adjourned.